You're not going to believe what the Biden administration argues and what we have to fight in order to get this basic information. I mean, this is a straightforward, I mean, obviously involves the president, but it's under the law, it's a straightforward FOIA request. I talked earlier about the issue of Joe Biden's cognitive issues. And you may recall Special Counsel Hur said, I'm not prosecuting Joe because jurors are going to think he's a nice guy with a poor memory and I won't win. Isn't that convenient? And he said, I based that not only on the transcript of my interviews, but obviously the audio. So we wanted, obviously, the transcript and the audio, and we were the first to sue for them. So we're the first to sue and the lead plaintiff in a lawsuit to get the audio. And since then, the Biden gang has said, oh, no, you can't have the audio. It will violate his privacy, executive privilege, and such. And A.G. Garland, the Attorney General, is going as in contempt of Congress to hide this video from Congress. That's how desperate they are to keep the, I keep on saying video, the audio. So we're in court, and we filed a major brief just today. Heritage Foundation filed a lawsuit after us. CNN and media court organizations also agree with Judicial Watch, so we're standing with CNN in this case and all the big media. Judicial Watch asked court to order the release of the audio of Biden's interview with Special Counsel Hur. In our brief, we called some of their arguments repugnant. Repugnant. It's a terribly political effort the Biden administration's engaged in to destroy FOIA in order to protect Joe Biden from having this audio released and the consequences of that. They don't want the public to know what the Justice Department and Joe Biden's up to when it comes to this document, prosecution or non-prosecution. Judicial Watch filed the first FOIA lawsuit and is the lead plaintiff asking that the Biden audio recordings of his interviews in Special Counsel Hur's criminal investigation of Biden's theft and disclosure of classified records. Now, the lawsuit already helped force the release of a redacted transcript of the Biden interview. The Biden Justice Department, in seeking to keep the audio recording secret, asked the court to ignore precedent and rewrite FOIA law. The Biden agency demands that a law enforcement executive privilege exemption be rewritten to help Joe Biden, wants to change FOIA law to protect, after 50 years of being politician, Joe Biden's privacy and his voice, and seeks to potentially end FOIA with a new argument that the possible AI alteration of the Hur recordings is reason to keep the recordings and any other government record a secret from the public. So the brief is an important brief. I encourage you to read it. And in fact, I'm going to read a good part of it to you right now. I'm going to take out some of the, because you're not going to believe what the Biden administration argues and what we have to fight in order to get this basic information. I mean, this is a straightforward, I mean, obviously involves the president, but it's under the law, it's a straightforward FOIA request. And in response, the Biden administration's asking the court to engage in a political process to blow up FOIA to protect Joe Biden. So I'm going to read part of it. I won't read all of it. It's available. We'll provide a link to it below. Exemption 5, that's the first exemption. Exemptions, when we reference exemptions, exemptions are reasons, as I call it, that allow the government to withhold information. There are exemptions for privacy and national security, exemptions to protect the release of information that might harm a criminal investigation. And they can cite those exemptions in order to withhold information lawfully. Now, there's always argument over whether the exemption applies and whether it's being properly asserted, but at least it's a legal process. And they just want to blow up that legal process. Exemption 5 generally protects against the disclosure of those records normally privileged in a civil discovery context, including records protected under the executive privilege doctrine. Now, that's the big fight that we're seeing between Congress and Garland. They're asserting executive privilege over these audio files. Executive privilege doesn't apply to that. And this is the introduction. Special Counsel Robert Hur interviewed President Joe Biden about his handling of classified information. The interview was recorded and subsequently transcribed. By the way, they had 2 recordings going on at the same time. We want both of them, by the way. The transcript, which DOJ has officially disclosed, contains both the questions and the answers from the interview. Yet the Justice Department is still withholding the audio recordings that contain the voice of the President of the United States, who has been an elected federal office holder for more than 50 years, speaking the same substantive information contained in the transcript. The law enforcement privilege component of executive privilege not only has never been recognized in a FOIA case, but also only applies to withholding information in an ongoing law enforcement proceeding. Nor does the Justice Department identify the information it seeks to withhold. The recordings don't relate to an ongoing investigation, all of which are fatal to the DOJ's executive privilege claim, as well as the Exemption 7A claim, which is the law enforcement proceedings protection exemption. Finally, President Biden has little, if any, privacy interest in his voice, especially after his long public career, and the fact that his answers are already public. Yet a substantial public interest exists in the audio recordings because the disclosure of them would enable the public to test the veracity of Special Counsel Hur's decision not to recommend criminal charges. And we want the audio recordings released in 14 days. Well, the court should order their release in 14 days after the case is fully briefed. In his final report to Attorney General Merrick Garland, Special Counsel Hur declined to recommend prosecution of Biden for his retention of certain classified records because he concluded in part, "We have also considered that at trial, Mr. Biden would likely present to a jury that, as he did during our interview of him, as a sympathetic, well-meaning elderly man with a poor memory. Based on our direct interactions with and observations of him, he is someone for whom many jurors will want to identify reasonable doubt. It would be difficult to convince a jury that they should convict him by then, a former president well into his 80s, of a serious felony that requires a mental state of willfulness." In response, Biden's White House counsel and his personal lawyer wrote several letters disputing the accuracy of the report. Even Garland says he disagrees with it. He won't prosecute Biden, but he's disagreeing with the reason for not prosecuting him. That's how things work in the Justice Department, by the way. It's Alice in Wonderland. Congress subsequently held a hearing about the special counsel's investigation and his conclusions. When asked about his conclusion that Biden came across as a sympathetic, well-meaning elderly man with a poor memory, the special counsel testified, "Chair, what I can tell you is that my assessment that went into my conclusions that I described in my report were based not solely on the transcripts. It was based on all the evidence, including the audio records." He reiterated, "What I tell you is that the audio recordings were part of the evidence, of course, that I considered in coming to my conclusion." Hur provides the best argument there is to get the audios. So as I said, Exemption 5 doesn't apply. This law enforcement privilege, this executive privilege, it doesn't apply. For the government to assert that the law enforcement privilege to apply, that they have to prove that there must be or they must show There must be a formal claim of privilege by the head of the department having control over the requested information. Assertion of the privilege must be based on an actual personal consideration by that official. The information for which the privilege is claimed must be specified with an explanation why it properly falls within the scope of the privilege. Focusing on the privilege's third element, DOJ does not identify what information it seeks to withhold. The tape is the recording, but what information on that do they want to withhold? It merely asserts that the audio recordings are exempt from production under the law enforcement privilege. As Attorney General Garland explained in his letter requesting that the President assert executive privilege over the audio recording, the law enforcement component of executive privilege can be asserted to avoid potential damage to proper law enforcement that would be caused by disclosure, including the chilling effect on sources of information. And obviously, an audio recording is a record, not information. So DOJ's failure to identify what information it seeks to withhold is fatal to its assertion. Second, even if the DOJ identified information, the law enforcement privilege only applies to ongoing criminal investigations. This is important. As DOJ admits, the criminal investigation into the possible unauthorized removal and retention of classified documents by President Biden is now closed. Therefore, the law enforcement privilege no longer applies to information, assuming there is any, that the DOJ seeks to withhold. So if this case was like Precedent, and we say we wanted this information, they would say, well, no, we're still running the case. You can't get evidence while we're running the case. But the case is closed. And they say there are these other proceedings potentially. They don't name what they are. There's like a future potential hypothetical proceeding that might be impacted. And that's not what the law allows them to do in terms of withholding information, to cover potential hypothetical secret proceedings that no one knows about. They're just making up stuff to hide the records. DOJ does not assert, nor could it, that the release of the audio recordings with disclosed, unpublished details of allegations against individuals reveal confidential sources, expose investigative techniques or methods, or interfere with the special counsel's decision-making process. It already disclosed a transcript containing the substantive information. So that relates to, well, you know, even if the case is closed, there may be material in the course of the investigation we have to keep secret, like a source or the fact that, you know, we can bug something in this way and not the other way. You can just, I don't need to tell you to come up with scenarios there. But this is just a transcript of Joe's interview. None of that's relevant. Fifth and finally, the mere fact that Congress subpoenaed the audio recordings and the President subsequently claimed executive privilege over them is little relevance here. That process of negotiation and accommodation is a political, not a legal process. FOIA, on the other hand, is a law passed by Congress and signed into law by the President. The court, therefore, can't act or ignore forever DOJ's and now the court's obligations under FOIA, especially since Judicial Watch submitted the FOIA request well before Congress subpoenaed the audio recordings. We asked this stuff before even Congress got to it. Not unusual. It's Judicial Watch. We're always ahead of the game. So they're all this executive privilege fight. That's a political fight with Congress. That's not a reason to withhold information under FOIA. It's a legal process. We have a right to know. You have a right to know about what the government's up to. because they're getting a political fight with Congress about this. I don't care. I do care about it. We're voters. But it shouldn't impact our right to get the documents independently under federal law. In addition to asserting that the audio recordings fall into the law enforcement component of executive privilege, the Justice Department also argues the audio recordings are protected from disclosure under FOIA Exemption 7A, which allows the government to withhold records or information compiled for law enforcement purposes, but only to the extent the production of such law enforcement records or information could be reasonably expected to interfere with enforcement proceedings. Again, what are the proceedings? Case is over. 15 years ago, an organization called CREW submitted a FOIA request seeking copies of records relating to the interview of Dick Cheney by Special Counsel Patrick Fitzgerald in a closed investigation into the leak of the name of a covert CIA officer. The specific records at issue were an FBI 302 report summarizing the interview and 2 sets of contemporaneous notes taken by FBI agents during the interview. DOJ failed to disclose the records and CREW sued. During litigation, the Justice Department asserted various claims of exemption, including Exemption 7A. So there was a case almost exactly like this 15 years ago. To support its claim, the Justice Department argued that disclosure of the withheld records could reasonably be expected to interfere with enforcement proceedings because there are likely to be future law enforcement investigations requiring the participation of White House officials, and disclosure of Vice President Cheney's interview could have a chilling effect and deter such officials from voluntarily cooperating with those investigations. Of course, that's just didn't turn out to be true, and the court didn't buy it. The court rejected the claims of the Justice Department. And even though the law hasn't changed in 15 years, DOJ again tries to withhold similar records, relying on the same arguments rejected 15 years ago. As DOJ admits, this Exemption 7A, this law enforcement privilege for ongoing proceedings, essentially, documents and material related to ongoing proceedings, protects law enforcement records that could reasonably be expected to interfere with enforcement proceedings that are, quote, pending or reasonably anticipated. So the case is pending. That's easy to understand. Reasonably anticipated. They're sniffing around someone. They're not sure whether they're going to prosecute. They may. They probably will. And therefore, they're not giving up any law enforcement related records. Makes sense, right? If it doesn't make sense to you under FOIA as to why they withhold stuff, it's you're right to ask the question typically. That's been my experience as head of Judicial Watch with these FOIA cases and the fights we've been having for 30 years at Judicial Watch. It also admits that the D.C. Circuit, which is the appellate court in Washington, D.C., so here, it's the lower court judge. He has to follow the rule set by the D.C. Circuit, the appellate court above him. The government admits, the Biden people admit, that the circuit has held that pending or reasonably anticipated is, quote, temporal in nature. Reliance on Exemption 7 may become outdated when the proceeding at issue comes to a close. If a law enforcement investigation is closed, Exemption 7A most likely no longer applies. Like it did 15 years ago, DOJ also asserts that the release of audio recordings could reasonably be expected to chill cooperation with reasonably anticipated future high-profile enforcement investigations. Possibly, maybe. However, this assertion ignores at least 40 years of binding precedent in which the D.C. Circuit has held Exemption 7A can't justify withholding records unless they relate to a concrete, prospective law enforcement proceeding. Makes sense, right? DOJ does not identify any prospective law enforcement proceeding, let alone a concrete one, to justify its withholding. It rests on a fallacy, merely asserting the obvious. DOJ will conduct high-profile investigations in the future. Such contemplated proceedings are not concrete, prospective, or otherwise reasonably anticipated in any way whatsoever. Now, the judge who handled this case similar case 15 years ago, Judge Emmett Sullivan, I think he's still on the bench. I mean, his case is kind of the case. Adopting the vague category hypothetical proceedings urged by DOJ would not only be inconsistent with precedent, right? But would also be in direct contravention of the basic policy of FOIA itself. Indeed, the dramatic and far-reaching extension to the current reach of Exemption 7A, that law enforcement, again, exemption, that the Justice Department urges this court to adopt is more properly directed to Congress to consider, and in its discretion to enact it if it sees fit. This court, however, is bound by the law in its current state, which does not sanction such an expansive reading of the statute. And things haven't changed since that decision, and that's the issue right now. They want to rewrite FOIA to protect Joe Biden through judicial fiat. And it gets worse. It gets worse. Of course, you got the privacy issue, right? Joe Biden needs some privacy. He's in politics for 50 years, 4 years as president of the United States, and we're invading his privacy by having a voice recording of his interviews in a criminal investigation while he's president. It's absurd. It's not like some poor schmo off the street was picked up and questioned and let go, and no one knows who he is, nor should anyone know who he is. He wasn't charged. Who cares? He's the president. A lot of people care. Our lawyers say it a lot better than I do, though, and I'm going to read it to you. DOJ has not identified a single case in which any court has concluded that the audio of an interview in which the transcript has already been released. Remember, the transcript's already been released, though it's been altered, further highlighting the need to get the full audio. Again, not a single case in which the court has concluded that the audio of an interview in which the transcript has already been released is protected from disclosure. Because of personal privacy concerns. In the one case in which such an audio recording was withheld, it was withheld not because of privacy concerns, but because the disclosure of the audio would have revealed the identity of a law enforcement source and would have put both the source and the government investigation in jeopardy. It's not the case here. We all know who's being questioned. DOJ's argument is novel. That's a nice way of saying they made it up out of whole cloth. Now, sometimes you can have a novel argument that it's kind of a winner, right? You know? But as our lawyer, Mike Bekesha, who wrote this, says, it makes little sense. It appears DOJ is arguing that President Biden has, quote, a substantial privacy interest in, quote, his pauses, hesitations, mannerisms, intonations, and tone when responding to the special counsel's questions. The D.C. Circuit has unequivocally, however, held that a claim to exemption from disclosures based upon a fear that the taped voice inflections of a person delivering a speech would reveal that person's emotional state would involve such a trivial privacy interest that the claim simply could not rise to the level of a, quote, a clearly unwarranted invasion of personal privacy. Remember, that's the language. Does it sound to you like releasing these audio tapes are clearly unwarranted invasion of Joe Biden's personal privacy? Of course not. Although not explicit, the DOJ seems to suggest that the New York Times should not be controlling, and that's the big case about that I just referenced here, namely because the audio recordings were made during a law enforcement proceeding, namely Biden speaking with the special counsel. But audio recordings are not booking photos or mug shots. Photos do not depict substantive information already available to the public. The transcripts already officially disclosed by DOJ, however, reveal the probing questions designed to elicit information about whether a crime was committed and Biden's response. These arguments simply don't hold water. DOJ also goes beyond FOIA. This is a killer. This is just crazy town. Apparently hoping to find an argument that sticks, protective orders by judges presiding over criminal civil cases are not relevant to the FOIA context. So they kind of want the equivalent of a protective order, which sometimes protects privacy and prevents the public disclosure of information in the context of discovery, meaning lawsuits. You can't use everything you get from a lawsuit and put it in the public domain. And a protective order protects the privacy rights of litigants and witnesses. This is FOIA. It's a disclosure statute. Similarly, arguments that the audio recordings cannot be released because of the dangers of modern technology are facile. If government records could not be disclosed because of the concern for manipulation, no record would ever be public under FOIA. Now, remember, the Biden people are saying AI should mean that we don't get the records because AI can manipulate the audio. Well, we don't need to have the document to be released to have AI manipulate Joe's voice in fake audio recordings. It's absurd. And it would be the end of FOIA. If government records could not be disclosed, as I read already, because of the concerns for manipulation, no record would ever be made public under FOIA. No record. Written, audio, video, all subject to media manipulation or computer manipulation, AI manipulation. They're just using AI to make everyone all excited. Even a printed record like a letter, memorandum, or transcript can be altered. In other words, DOJ's, quote, concerns about malicious manipulation of audio files have no limiting principle, meaning there's no line that can be drawn anywhere. They would apply to any record. In addition, it's not entirely clear why the fear of manipulation even falls within the FOIA's personal privacy exemption. Now, the thing about privacy is it's not absolute. You can have a privacy interest, but it's weighed against the public interest. So is there public interest in the release of this material? I mean, come on, I don't have to explain it to you. The Justice Department's pretending there's no public interest in this. Even if President Biden had more than a trivial privacy interest in his voice speaking substantive information that's already been made public, the public interest far outweighs any such privacy interest. Contrary to DOJ's assertion, Judicial Watch seeks access to the audio recording not out of general public curiosity, but because an open question remains about whether Special Counsel Hur's conclusions that Biden should not be prosecuted for his mishandling classified records is supported by the evidence. Releasing the audio recordings would shed light on the special counsel's performance of his duties. Stated another way, the relevant public interest is not to find out what Biden himself was up to, but rather how the special counsel and the Justice Department carried out their respective duties to investigate and prosecute government or criminal conduct. And they say that releasing the audio would provide any little meaningful information to this decision process. But it's contradicted, as we note, by Hur himself. He said, I made this decision in part based on the audio. So of course it's going to be useful to find out what's in the audio. Of course, Congress asked about this as well. And not only that, the attorneys for Joe Biden make it an issue. The White House counsel, the top lawyer in the government, at least in the White House, for Joe Biden, acting seemingly as his personal attorney, it looks like, and Joe Biden's personal attorneys have publicly challenged the special counsel's report, including the assessment that the special counsel based his determination on, the assessment of his poor memory, right? In fact, White House counsel and Biden's personal attorneys have jointly sent at least 3 letters in which they dispute the accuracy of the special counsel's report. There's a big issue here. The release of... Oh, wait, I think I just knocked down my... Did I knock down my... Hold on one second. I'll put it over here. The release of the audio recordings will therefore assist the public in determining whether the president or special counsel's assessment was most accurate and whether special counsel's conclusions were supported by the evidence. Biden's disagreement with the special counsel's assessment underscores the public's need for the audio recordings. And Congress has asked for the records. So Congress thinks it's in the public interest. As we summarize, Congress says so too. And of course, generally, whether Hur appropriately pursued justice by recommending to the Attorney General that criminal charges should not be brought against Biden is even more important these days because another special counsel, with approval by the same Attorney General, is currently prosecuting Trump for engaging in similar actions, allegedly. In addition to Trump being both President Biden's former political opponent and the current Republican nominee, President Trump was the only former president or vice president to be prosecuted for such actions. The public, therefore, has a significant public interest in knowing whether the DOJ had the evidence but nevertheless pulled its punches when it came to its boss, the current president. And this is the stuff that gets repugnant. I talked about this New York Times case. DOJ asserts the D.C. Circuit's decision, so they're trying to get a lower court to overturn an appellate court decision. That's not the way it works. Supports its personal privacy claims. First, a special counsel's interview of a sitting president about actions he took related to his vice presidency and presidency is not an event of extreme sensitivity. Like the last seconds of the Challenger's crew lives before the shuttle exploded. You heard that right. The Biden Justice Department is saying that the privacy for Biden's interviews with Hur are warranted because they're just like the privacy that would be expected and was provided for those poor astronauts who died and their utterances and screams at the last minute. Joe Biden's interview with Hur is just like releasing the audios of astronauts dying in an explosion. The Justice Department is just beneath contempt in making this argument, in my view. As we say, such a comparison is repugnant. Indeed, indeed. The district court found a substantial privacy interest in the sound of the astronauts' voices because exposure to the voice of a beloved family member immediately prior to that family member's death would cause the challenger's family's pain. And such considerations, we're forced to say, don't apply here, obviously. And plus, the transcripts of the astronauts were released. Every utterance. That isn't the case here because they admitted we forced them to disclose that the transcripts were not accurate. They were altered. So they're telling us to rely on inaccurate transcripts. So there you have it. You can read the full thing. And the reason I took the time to go through it with you here in detail, I mean, it shows you the heavy lifting that Judicial Watch's lawyers have to do to get access to basic information. And that we just don't come on and complain and yell, why are they withholding materials? We have to fight about it in the court and do careful legal analyses to convince a federal court judge to force a powerful government agency, the Justice Department, to give us the document. And it requires a lot of work. And plus, what they're doing here is so destructive potentially to FOIA. Because if the court does what the Justice Department, Biden's Justice Department wants the court to do, or the courts above them to do in the end if they appeal it, as I note, would upend FOIA. As I say in the press release, we hope the court rejects the Biden Justice Department's political request to rewrite FOIA law to hide the Biden tapes. The Biden administration wants to destroy FOIA in order to protect Joe Biden. I mean, that's what's happening right now. So, what's next? Well, CNN filed their brief. I haven't been able to read it. They just filed it before I came to do this video. And then Heritage, our friends at Heritage, are going to file their brief. And we're probably all going to say the same thing, more or less. Lawyers will add words, but the arguments are generally the same. And the nice thing about having three different plaintiffs in this regard is that they all have their separate twists on the argument, so that will be useful for the court to have, and will make our case, I think, more powerful, having two other folks agree with us, including our great friends at Heritage and the lawyers working for the massive media coalition that agrees with Judicial Watch here. And I guarantee you the media isn't going to focus on this, even though they agree with us, and won't expose and report on the ongoing Biden administration effort to destroy FOIA to protect Joe Biden. So I think it's a big deal. I think it's worth talking about. I should have read the whole darn brief. It's so important. And now the government will have some time to respond. We have time to respond again. And then it will be before the court, I think, by the end of July. So hopefully the court moves quickly and we win, but we'll see. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.